Good morning, everyone. I request all to please take their seats. Please be seated. Thank you. 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 Honorable Mr. Justice N.V. Ramanna, Chief Justice of India, is with us, sir. Good morning, ladies and gentlemen. I, Aparna Swami, Joint Registrar Rules, have the distinct pleasure of welcoming all on behalf of Delhi High Court to this national seminar on adjudication of intellectual property rights disputes in India. It is no exaggeration to say that Delhi High Court has many firsts to its credit in the field of intellectual property dispute resolution. Given the number of IPR cases filed in Delhi High Court, we have had the occasion to study this subject closely. Through this seminar, we wish to share with you our experiences and explore solutions to common problems. I am also delighted to inform you that we are now in the course of adding another chapter to this exciting journey of intellectual property protection. The transfer of jurisdiction related to IPR disputes to the high courts requires proper mechanism for administering these cases. To deal with the docket that lies ahead, the Delhi High Court has prepared a blueprint which will govern such disputes and is tailored to the peculiarities presented by intellectual property cases. Having said that, we put in motion today's program. I request all to please rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उत्कल जलधि तरंगा तब शुभ नामे गाजे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगलदायक जय हिंद भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
I now request all the dignitaries present on the dais to kindly light the lamp to pay tribute to Ma Saraswati. I request Honorable Mr. Justice D.N. Patel, Chief Justice Delhi High Court, to felicitate Mr. Justice N.V. Ramanna, Chief Justice of India. Thank you, sir. I now invite Honorable Mrs. Justice Pratibha M. Singh, Judge Delhi High Court, to felicitate Mrs. Nirmala Sitharaman, Union Minister of Finance and Corporate Affairs. Thank you, Madam. I request Honorable Mr. Justice Sanjeev Narula, Judge Delhi High Court, to felicitate Honorable Mr. Justice D.N. Patel, Chief Justice, Delhi High Court. Thank you, sir. I now request Honorable Mr. Justice D.N. Patel, Chief Justice, Delhi High Court, to kindly welcome the dignitaries.
Good morning to everybody. Honorable the Chief Justice of India, Sri N.V. Ramana Sahib, Honorable Union Finance and Corporate Affairs Minister Srimati Nirmala Sitharamanji, Honorable Judges of Supreme Court of India, Honorable the Chief Justices of various High Courts of our country, my sisters and brother judges of Delhi High Court and other High Courts, Attorney General and Solicitor General of India, Principal District and Sessions Judges, Judicial Officers, Senior Advocates, Members of the Bar, representatives of the law firms and officers of IP offices, senior bureaucrats, ladies and gentlemen. I welcome you all to this first of its kind National Seminar on Adjudication of Intellectual Property Disputes in India. It is my proud privilege and honor to welcome our dynamic Chief Justice of India, Sri N.V. Ramana Sahib. His Lordship's very presence is a matter of great honor for us. I, on behalf of Delhi High Court, extend a very warm welcome to His Lordship. Srimati Nirmala Sitharamanji, the Union Finance and Corporate Affairs Minister, is also amongst us. It was her vision only which eventually led to the enactment of the Tribunal Reforms Act 2021. We welcome you, Madam. It is also a matter of great pride and honor for us that Honorable Judges of Supreme Court of India, the Chief Justices of the other High Courts have also accepted our invitation and have chosen to attend this seminar. I welcome all the distinguished invitees who have joined this program through physical mode as well as through virtual mode. I may now give a small backdrop of the factual matrix which has prompted us to organize this national seminar. The Intellectual Property Appellate Tribunal, IPAB, was abolished, and eventually the Tribunal Reforms Act 2021 came into force. This act gave jurisdiction to the High Courts to hear the appeals emanating from Intellectual Property Office, as well as original proceedings under various IP-related legislations like Trademarks Act, Copyright Act, Patent Act, Designs Act, to name a few. With the abolition of IPAB, the jurisdiction of the High Court with respect to IPR matters have expanded considerably. As per the statistics placed before me, we have received around 2,500 cases relating to IPR after abolition of IPAB. In order to streamline the inflow of such cases, a committee was constituted by me. The committee was comprised of Honorable Mrs. Justice Pratibha NC and Honorable Mr. Justice Sanjeev Narula, who are on dais, and they were requested to review the manner in which the litigation relating to IPR matters was to be handled by the Delhi High Court. I must compliment the committee for the hard work put in by them. They came up with the draft rules one after the other and took inputs from all the stakeholders repeatedly. After comprehensive evaluation of the rules were framed, which have now been notified by Delhi High Court. In similar manner, the rules have also been framed for patent cases also. And over and above earlier two members of the committee, Honorable Mr. Justice Naveen Chawla also put in tremendous effort and hard work in drafting the rules governing patent actions. These rules have also been notified by Delhi High Court. In today's compilation, we have given these two rules, which will be, the booklet will be released today by the dignitaries on dais. IPR is not a simple subject. This field is undoubtedly a complex one with no geographical boundaries. Undeniably, the disputes relating to the intellectual property may look like a private in nature, but in reality, most of the time, these also involve elements of public interest. Protection of intellectual property does not only connect to the right to exploit the business opportunities, but also to the sense of mental satisfaction of the creator. Delhi, being a capital of the country, has always been a hub for IPR matters since its inception. The data presented before me shows that since the year 2000, approximately 11,000 IPR cases have been filed and approximately 90% of the cases have been disposed of till the date. I would not mince any words in saying that many of the rulings given by the Delhi High Court have become path-breaking judgments which are quoted as precedents not only in India but internationally as well. Delhi High Court has successfully dealt with most of all kinds of IPR matters during the last 5 decades. Almost all important cases in the field of IPR have originated from Delhi, be it Apple Computers in 1980s, Whirlpool in 1990s, domain name cases biswarianaukri.com in 2000, patent cases of Hoffman versus Cipla, Marg versus Glenmark, telecom cases involving Philips or Ericsson, etc. The list is indeed very long. I may also be permitted to say that because of the enormity of the nature of litigation in Delhi, exceptionally high quality of bar, and deeper appreciation of such matters by our High Court, in the times to come, I am sure that it would be safe to say that Delhi High Court is having IPR over the subject of IPR. I am happy to inform that Intellectual Property Division, IPD, has already been established in the High Court of Delhi. Establishment of independent IP division itself will create a speedy mechanism for IPR disputes, and the IPD division would be dealing with all IP cases under one umbrella so as to maintain consistency and clarity and to avoid duplication and multiplicity of the proceedings. As we know that IPR disputes involve both domestic and international litigants. It would be desirable to have uniform system of dealing of such type of cases across the country. With this purpose in mind, the Delhi High Court decided to hold this seminar. This national seminar is only a beginning under the dynamic leadership of Honorable the Chief Justice of India. When we met His Lordship in this regard, His Lordship was kind enough to immediately confirm his participation in this program. This shows the importance of this program. His Lordship had also led the Indian judges and advocates at Tokyo, Japan, and had delivered in 2016 excellent lecture with detailed power presentation. 1 or 2 photographs we have already given in the booklet to be released today, and in the kits we have given to all the participants. I am sure that this court as well as other high courts in the country would hold such type of seminars and conferences on a regular basis so that IPR cases are handled in the most efficient manner. I once again welcome all of you who are present in this august gathering. Thanks and Jai Hind.
Thank you, sir, for extending such a warm welcome. I now request Honorable Mrs. Justice Pratibha M. Singh, Chairperson, IPG Committee, to present the vision of IP Division.
A very good morning to all of you. And it's such wonderful atmosphere to see all the entire IP fraternity here today. Honorable Chief Justice of India, Justice N.V. Ramana, the Honorable Finance Minister, Mrs. Nirmala Sitharaman, our Chief Justice, Justice Patel, Chief Justices of the various high courts who've been kind enough to accept our invitation, judges of the high courts across the country, and of course, our own Delhi High Court. IP stakeholders, members from the IP fraternity, ladies and gentlemen. We assemble here today to mark the beginning of our momentous journey in the field of intellectual property adjudication. Never before have so many distinguished dignitaries in the legal system, led by none other than the Chief Justice of India, come together to express the resolve for an efficient and modern intellectual property adjudication, adopting the global best practices harmonized with our own laws. Therefore, the fact that we have the Chief Justice of India and so many distinguished Supreme Court judges who've joined him today is a proud privilege for the Delhi High Court, and we are very, very thankful to all of you having been here. I would say that intellectual property litigation has come a full circle in India. We had all the litigation in the high courts, it went to the IPAB, and it's now back. Therefore, in the article that I penned, I called it the homecoming. So, it's the entire litigation is coming back home. While the substantive IPR laws in the colonial era was similar to what was in England, after independence, India has created its own statutes, and over the years, we've developed our own very rich jurisprudence, and Indian judges have decided the most complex IPR disputes, laying down principles which are matching with the global jurisprudence in this area. The law in India changed post the TRIPS agreement, which is when the IPAB was established. However, during the period when the IPAB functioned for 17 years, between 2003 till 2021, it faced a large number of challenges which were both procedural and substantive. Many tribunals faced lots of problems, and the IPAB was no exception. The chairpersons of the IPAB faced daunting challenges in running the tribunal, but unfortunately, for various reasons, the IPAB could not get off the mark. So the Tribunals Reforms Act has been enacted last year, and in the summer of 2021, the High Court started receiving a large number of cases from the IPAB, and that's when, under the leadership of our Chief Justice, Justice Patel, the committees were constituted for patent suits and the IP division, and the committees kept in mind the various models from across the world. For example, the Patent Court of UK, the Intellectual Property Court in Japan, the Central Intellectual Property Court in Thailand, and various other countries which had similar expert bodies. The path-breaking decision to notify the IP division took place in July of 2021, immediately after which the Intellectual Property Division has been functioning. However, in order to create a proper structural framework and foundation, the rules were drafted, and in order to frame these rules, we've been able to look at models and rules from at least 50 jurisdictions of the world and drafted them. The rules have been circulated in the brochure, which is in your conference kit. I must say, on behalf of the Delhi High Court and on behalf of the committee, speaking for both the judges, the IP fraternity has been extremely forthcoming in its deliberations for these rules. We received 3 rounds of detailed comments from more than 50 to 60 stakeholders, which included, of course, the IP lawyer community, law firms, senior advocates, even Justice Manmohan Singh, who was earlier part of the IPAB. But the most important thing was we also received international bodies like the AIPPI, the IPAA, the Intellectual Property Owners Association from USA, the Japanese Intellectual Property Organization. All of them gave their comments. We had a detailed deliberations in the stakeholders meeting, which was held in December, the pictures of which you saw here, which were being shown prior to the commencement of this session. So it has been after detailed deliberation, a large amount of in-depth study. The comments were very, very detailed, and some of the features which have been incorporated in the rules was due to the detailed comments that we received from stakeholders. And it's wonderful to see all the stakeholders who are here with us today. The IP division rules we would be discussing in the panel discussion. Some of the highlights are that this division would not only be dealing with suits and matters from the IPB, but it's a consolidated division which will deal with writs, which will deal with revision petitions from the commercial courts, the appeals from the commercial courts at the district level, and the suits and all the matters which were earlier being filed with the IPAB. It would use the most modern form of technology for remote recording of evidence because experts all the time cannot travel from various countries. So transcription facilities would be available in the IP division. The features such as hot tubbing, over which there has been a couple of judgments already in the Delhi High Court where two experts are pitted against each other, will also be used. There is what is called a concept of litigation hold notice. That is that when a litigation is about to be commenced, a person can give a notice saying, please preserve all the data relating to the manufacturing process or the technology being used, the excipients used, raw materials used, so that these are not destroyed once a litigation hold notice is given. Confidentiality clubs will be constituted, over which we now have very rich jurisprudence within the Delhi High Court. The feature of damages is one major issue in IPR litigation. So there are rules which have been formed in which there are certain factors which have been enumerated which the court can consider, and the pleadings etc. can be filed in accordance with those rules to how to frame damages. And another very interesting feature which happened due to an input which we received from a law firm who had a lawyer with a visual disability is that these would be the pleadings in the IPR division would be with the OCR capabilities, meaning that people who have a visual disability will be able to read them with their own proper readers in accordance with the Right to Disabilities Act. And early neutral evaluation by technically qualified experts, etc. is also permissible. The High Court has seen from the data which has emerged, which of course we will be presenting even during the panel discussion, Justice Narula hopefully, and we have seen that, for example, in the year 2000 to 2005, there were only 3 patent cases. However, from 2015 till the period of the pandemic, Delhi High Court has received 300 fresh patent cases. So it's gone up 100 times, the patent cases filing. This is statistics which are real, and therefore the entire purpose of the division is to ensure that there's a proper structural framework which helps in dealing with IPR cases, especially the technical parts. We are going to have a very detailed panel discussion with judges from various high courts. I'm sure you've all seen the program. I look forward to this panel discussion. Coming to the vision of the IPD, I want to say a few things. The intellectual property regime in any country is one of the benchmarks of its global standing. The efficiency of the IPR regime is also a measuring standard for determining where a country stands in terms of its development. IP-related issues form parts of discussions of free trade agreements, multilateral negotiations, and almost every agreement which is negotiated now at the international level. As India is a knowledge economy, one of the measures for the preservation and recognition of knowledge is enforcement of IP. Recent trends point out towards an all-round increase in filings of trademarks, patents, but there is no reason for complacency. India should strive to improve its systems and push the standards while at the same time retaining its social and cultural ethos. India is the largest generator of creative works owing to its rich diversity in languages and cultural heritage. Copyrighted works from India are disseminated and published across the world, but royalties that India receives is minuscule compared to the quantum of creative works that are there. An IP-friendly adjudication regime would encourage local businesses and also recognize foreign IP owners. That is not to say that the IP field is an elitist or a sophisticated field meant for the rich people. That conception is completely misplaced. More than 80% of the trademarks which are filed belong to domestic businesses, and till 5 years ago, only 20% of the patents which were filed were domestic. However, recent trends show, as of last year, 40% of the patents filed in India relate to domestic inventors and domestic inventions. Thus, India ought to aspire to increase the percentage of patent filings, increase innovation, and this shows that these filings show that India is moving in the right direction. This is the time to recalibrate IP adjudication across the country. Apart from providing efficient systems for those litigants who knock the door of our courts, the base of IP litigants who seek protection, enforcement should be increased. Individuals and small inventors ought to be provided a system which welcomes them. The costs of adjudication ought not to be prohibited. The manner in which this can be achieved is by creating an IP adjudication system which is uniform across the country, beginning with the commercial courts at the district level up till the IP divisions in the high courts. Accessibility ought to be improved without compromising on the quality of adjudication. This can be achieved through interlinking IP courts and the commercial courts with the IP division in various high courts and sharing of best practices and knowledge. In fact, this seminar is one step towards that direction. The interlinking of these high courts, IP divisions and the commercial courts would lead to quick adjudication which is transparent and of high quality. Assistance required for the commercial courts and the IP divisions should be readily available through this network in the form of procedural assistance, access to experts from various areas of law, economics, science, and the continuous engagement on such a platform. India's legal position, both statutorily and by judge-made law, including sections such as 3D, received some reluctance in the initial years. However, as the pandemic would show, India's position has been affirmed as one which is having the right word for intellectual property, and that is balance. While recognizing the rights of IP owners, the larger purpose of IP has not been forgotten by India, and that is for the betterment of society. The role of IP and persons who practice in this area is very crucial to ensure this balance. The IP jurisprudence in India is extremely rich and thought-provoking. In respect of India's IP jurisprudence, the need of the hour is to disseminate this jurisprudence globally, which is not yet happening, and therefore creation of these divisions and a large network between high courts should help the dissemination of IP jurisprudence. The creation of the IP division will hopefully enable this dissemination, and it would result in data analysis and generation of annual reports which would showcase India's achievements. As informed by our Chief Justice just now, more than 11,000 cases have been filed in the Delhi High Court since 2000. 90% of these cases have been disposed of. Now, with the matters being received from the IPB, the pendency of the IPR cases in the Delhi High Court would be 4,000 to 5,000 cases. This actually confirms the reason for the creation of the Intellectual Property Division. India's tryst with intellectual property has moved from the scriptural ethos of sharing to a country which introduced IP with reluctance when the chips happened. And now the story of the 1990s is over. In the 21st century, India is an IP-friendly country with its proud innovation and wishes to build on its strength. For it to move forward in this direction, the IP adjudication has to keep pace. In order for the growth in innovation to be holistic and all-pervading, the court system has to become innovation-friendly to both Indian and foreign IP owners. The Intellectual Property Division is just one defining step towards the same, and I would just like to end by saying there are miles to go before we see. Thank you so much, and thank you for the patient hearing.
Thank you, Madam, for presenting the background and the vision of IPT. I now invite our guest of honor, Mrs. Nirmala Sitharaman, Union Minister of Finance and Corporate Affairs, to address the august gathering.
Morning and namaskar. Honorable Chief Justice of India, Sri Ramana Garu. Honorable Chief Justice of Delhi High Court, D.N. Patel Saab. Justice Pratibha Singh, Justice Sanjeev Narula ji, judges of the Supreme Court, Chief Justice of several high courts, judges and other invitees for this very important day. I'm honored to be a part of this program today, which is a national seminar. We are talking on the adjudication of IPR disputes in India. It was rightly recalled by the Chief Justice of Delhi High Court that this exercise had started sometime when I was in the Commerce Ministry. I'm indeed grateful for the judiciary to remember that little bit of a role that I played in the commerce. Those were very challenging days in terms of bringing out a policy on IPR, getting the stakeholders to discuss with the government for making the policy, and also understanding how we can strengthen the IPR ecosystem. India is at a stage where growth and the focus on development has got to be strengthened from every side. IPR plays a very important role in it. In fact, when the government announced the policy on startups and came out with steps to encourage startups, the spirit behind that was we should also give the startups the advantage by providing such policy framework, supports through schemes, so that the innovative thought of a startup, otherwise a startup is no different from any business which really starts up, but that idea of bringing in innovation into the thought with which they would like to build a business or module had to be given all kinds of support. So the whole push from the government was to encourage startups, have a formal registration mechanism, also understand their requirement for protecting their IPR. And also the IP protection together with giving them the opportunity to be able to commercially scale them up and build on it. Today, if I can quickly jump over 5 to 6 years, today we are seeing a number of these startups qualifying to become unicorns as well. This couldn't have been possible just with the government giving up a lot of restrictions which were there earlier, which were probably becoming burdensome. So simultaneously, as we were removing a lot of restrictive rules and regulations, we were also making sure that with various schemes that we were able to support these innovations and also give a framework with which they can work. Now, not just for startups, but also from the point of view supporting R&D itself in this country. R&D in this country has had steady flow of money coming from the government as a support, but to give a leap forward, it required for the government to be able to apportion that kind of money for R&D, whether it was specifically for space, whether it was for atomic energy, or for looking at very many genome-related activities, pharma-related activities, and simultaneously recognizing that India had a great advantage in bulk drugs manufacture. So there were so many different ways in which the idea of supporting patents, supporting copyrights, were all got to be encouraged, and government duly recognized it. But as was mentioned by Justice Pratibha Singh, the question of wanting to give enough support for rights protection through law was the matter on which there were a lot of discussions happening. I was pleasantly surprised for Justice Pratibha to recognize the travails of the IPAE, and as that was one of the things which was concerning most of these new startups, we also wanted to engage with the judiciary, and to some extent the engagement happened over several years. resulting, of course, end of the day, last year when we really removed the tribunals and passed on the entire load of cases which were piling up to the courts themselves. But with a word of appreciation, I want to uh, recognize the role of Delhi High Court for having looked at that load which was piling on to them as not a challenge, but take it as an opportunity that today we are here recognizing the fact that a division has been created, and that is just not created and left there. Consistent efforts by framing or having a committee look into getting a framework and also setting up the rules have all been quickly followed up, that today we are in a position to say a systematic approach to deal with the IPRs is happening, and that is where this quoting of the statistics saying numbers have increased is said with a sense of, yes, we can manage that, rather than saying numbers are increasing, how are we going to cope with it? So I appreciate the effort which has gone in making the framework, in setting the rules, and with a tone of assurance, uh, giving the picture that India's jurisprudence is very well evolved, that today, even handling a complex and global matter such as the IPR is happening with certain sense of confidence and strength. And indeed, I would like to have a word of appreciation and also respect for the Chief Justice of India for having been very supportive of this entire effort, and that gives a strength for judiciary all over the country to be able to see that there is a well-established, well-thought-through process through which issues of IPR will be handled from now. Just to give you the numbers, which are very interesting, which partly got gathered when the two judges spoke before me. In 2013-14, there were 4,000 patents which were filed and granted, whereas now, in the last year, that has increased to 28,000. So this cannot happen unless there is a confidence in those patent seekers to know that they apply, they get it in due time, and if there are any complexities, the judiciary is there to dispense justice. So that is the confidence which has rapidly increased the number in the patents application and granting. Similarly, in trademarks, the number was 70,000 applications and granted patents, trademarks in 2013-14, whereas that has increased to 2.5 lakhs in the last year. Similarly, in 13-14 copyrights, there were only 4,000 copyrights granted, whereas that number in the last year has crossed 16,000. So these are not small numbers, and I'm very glad for these numbers, because this is where the strength of the economy in supporting such innovations and copyrights, all of which, when scaled up, are going to have a very strong ripple effect into the economy itself, and that would generate its own ecosystem and also revenues. So I think the boost which is given through the support of judiciary has actually encouraged more innovations, more patents, and more copyrights coming into India, and all the more impressive that I hear from Justice Pratibha, who's already gone into the statistics, done a deep dive, to say that a significant number of them are very Indian themselves. So that is a very strong message which comes through as a result of concerted attempt to give strength for IPR. A few steps which the government has, again, following from 2014-15, has taken up is to recognize several of these services which are so infused with innovation, such as the drone technology being now expanded into agriculture, expanded into services, and recognizing the service providers of drones as, like the way we say SaaS, service as a service itself, the software services. Similarly, in drones, we've come up with drones as a service itself now, as a result of which you're not just creating jobs, but are able to accommodate from a commercial sense the technologies and the innovations which are happening in the drone area. Similarly, for R&D in defense, we have said that industries and startups and academia with 25% of all the defense R&D budget will be going over to them now. So there's going to be a lot of activity in that as well. So if these are gradually, because of the support and also in a way the captive nature of things which are being procured by the government, these are going to be very strong encouragements for greater activities, generating greater IP applications, I would think. And that itself is going to be, therefore, necessarily having an impact on the judiciary. Battery or energy as a service is also coming through, which again has a lot of innovation component in them. I've already spoken about the genome and also the geospatial areas. Semiconductors are also getting a big boost through the budget. Artificial intelligence, this is the world of Web 3.0, Industrial Revolution 4.0. So these are all driven with technologies and also through innovations. So as a result, the economic activity itself is moving more towards these areas, which are so dependent on getting their patent registered, copyright registered, and answering questions related to that. Rightly, these are not going to brook any borders. These are things which are going to be across international borders, and there is just not going to be any resistance from countries and technologies so long as they comply with the law of the land. And that is where I think judiciary has a big role to play. And now that the bench is being division has been created, the bench has been set up, you're going to be able to face the challenge of increasing numbers reaching the courts. But with this kind of a support, knowledge being shared, rules being set, framework being provided, I think it will be far easier for the courts to take up this challenge. One other scheme which I'll draw the attention of this August audience is that we in the government in 2016 came up with a pilot scheme for intellectual property protection, SIPP, wherein the cost of the facilitators or the payments that they had to make for challenges in the courts were all borne by the government through the Office of the Controller General of Patents, Designs and Trademark. That scheme has now been extended to 2023. It was brought in 2016 as a pilot scheme through which the payments or the charges being made by the facilitators, the patent agents and so on will be borne by the government through the Office of the Controller General. That scheme, after having been launched as a pilot scheme, has now graduated year on year moving forward, but now we have extended it to 2023, and I guess that's going to be one of the most important ways in which we can support technology and innovation. But that support is only for ensuring that people don't hesitate from the cost point of view. Because if it is going to be prohibitive costs, people are going to hesitate. But we need all the innovations. We need all the patents. We need the creative thought, because economy stands to benefit in a multiplier kind of a scale. If you look at it, it's far more than the general routine activities, which can, if you put it in a scale of 1 to 10, the general manufacturing, general production activities, if they give you a level of 3 in a scale, innovative activities bring in about 7 to 8 is the informal understanding of the importance of these innovative ideas, patented ideas can bring to the economy, which is so required. Without taking more time, I'm immensely grateful for the support that the Delhi High Court and particularly Chief Justice Patil Saab has brought in. Chief Justice of Supreme Court, I'm grateful that he's been here physically to support this whole step taken by the Delhi High Court, and the two judges, Justice Pratibha and Justice Narula, for having spent arduous time in getting the framework ready, the rules ready, and as a result, I would think the country will benefit from this great exercise. I wish today's proceedings all the very best, and thank you for having me here. Thank you.
Thank you, madam, for sharing your valuable thoughts with us. I now invite our chief guest, Honorable Mr. Justice N.V. Ramanna, Chief Justice of India, to kindly address the gathering.
Srimati Nirmala Sitharaman, Honorable Union Minister for Finance and Corporate Affairs, brother and sister judges of the Supreme Court, Brother Justice D.N. Patel, Chief Justice of Delhi High Court, Chief Justice of various High Courts, Sister Justice Pratibha Singh, Justice Sanjay Narula, brother and sister judges of various High Courts, Mr. Mendrata, Secretary Law, Varun Mitra, Secretary Justice, Judicial Officers of Delhi, Registrars of the Supreme Court, Law Officers, Senior Advocates, Members of the Bar, other distinguished guests, media persons, and ladies and gentlemen. Very good morning, all of you. Except me, all the four dignitaries on the dais are very well qualified on the subject and their authorities on the subject. I am a lay person on this topic. However, I will try to do some justice. I am happy that 18 Chief Justices across the country and 54 senior judges, number 2 and 3 judges are here to attend this conference. It shows the importance of the topic. I am relatively a newcomer into this field of intellectual property rights. Even though I am a science graduate, those days we are never aware of what is this intellectual property rights. It is a alien to me and my generation. My understanding about the subject is very limited because as a judge only I dealt few cases. And once again in 2016 I got an opportunity along with Justice D.S Kothari, the then Chief Justice, myself and Justice Kishan Dave, Pratibha Singh and Attorney General at that time, Mr. Rothke, we all toured almost 6 days South Korea and Japan, particularly on these issues to explain the entrepreneurs of Japan and Korea how safe the Indian judiciary is, how independent the Indian judiciary is. Because any person who wants to invest in this country, they are scared of dependency, time taking, and independence of the system. However, we try to dispel their apprehensions, and we have prepared almost it's a 1 hour session, 15 minutes a slideshow, and 5 minutes explaining by me about the Indian judiciary, how the hierarchy and other issues. Pratibha Singh and Rothke used to explain the legal position and the decided cases, and to create confidence in those people who want to invest. I can say this is a successful tour. Again, now today, I am forced once again to roll it into the IPR subject. Intellectual property is a field of law which protects creativity and innovation. Its importance is also felt during the ongoing pandemic. Innovation, and that too quick innovation, has become the order of the day. With the onset of the pandemic, vaccines and medication had to be researched. Trials had to be conducted and commercial scale of manufacturing had to take place within a span of 2 months. When the future generations will look back, the past 2 years of pandemic will tell the story of human resilience and power of innovation. IPR touches every aspect of our life, from the food we eat, to the books and movies we enjoy, to the appliances and tools we use. IPR is not a new chapter in Indian jurisprudence. The earlier Patent Act of 1970 was framed with an objective to provide a reasonable balance between adequate and effective protection of patents on one hand and the technological development and public interest and specific needs of the country on the other. With the advent of economic liberalization, the country's IPR regime has undergone a rapid transformation. This transformation has been driven by the compulsions of integrating our economy with the rest of the world. During the Uruguay round of the trade negotiation under GATT, the developed world pushed for mandatory inclusion of IPR in every sphere. Considering the fact that 99% of the global patents were held by the developed world, any agreement for their protection was perceived as favorable to them at the cost of developing countries. The inclusion of intellectual property in the agenda of trade negotiation was a bone of contention between the developed and developing countries. For some, TRIPS was a product of bargain, while others view it as a coercion. Generally speaking, the popular narrative in the third world was that IPR was a self-serving tool of the developed world to further their revenues from emerging foreign markets. As India was embarking on liberalization, it hoped that the international trade negotiation would help developing countries to integrate with the global economy on favorable terms. In the absence of level playing field, India and other developing countries had to negotiate over several rounds, aided by domestic pressure exerted by the opposition and the civil society. We had to bargain hard before achieving certain concessions while signing TRIPS. Today, India's position as the pharma hub of the globe is largely attributable to the existing IPR regime. Several pharmaceutical multinational companies have been contracting research and development to national laboratories in India for the last 2 decades. The existing framework has enabled a massive growth of pharmaceutical exports by India, with local firms building capabilities in making generic products. The lower price of generic drugs has enabled access to life-saving medicines for those in the developing and underdeveloped countries. Indian pharma has been producing low-cost treatment for HIV, tuberculosis, and malaria, and are the major vaccine producers of the world. Today, India has rightfully earned the title of Pharmacy of the World. Whenever we talk about the IPR regime in India, it always reminds us of Novartis of India case. The Supreme Court stopped the practice of pharma industry to extend the patent period by simply tweaking some constant element. This decision has helped common man by ensuring that life-saving drugs are available at an affordable cost. The second sector I would want to concentrate on is the impact of IPR on agriculture. As a son of a farmer, my views can be taken to be biased. I understand the hard work and labor involved in farming. Agriculture is the backbone of our country. Our history in agriculture encompasses our ethos, culture, and living. In India, the art of developing new varieties and techniques usually gets passed on from generation to generation. Unlike Western countries, agriculture is seen as a community right. In modern times, private companies have entered this arena in developing new varieties and high-yielding plants. Huge investments in biotechnology have resulted in slow degradation of community knowledge and it is replaced by private ownership. These companies expect a certain level of protection for the variants of plants they develop. In order to strike a balance between innovation and concerns of such rights of farmers and food security in line with TRIPS, India enacted the Protection of Plant Varieties and Farmers' Right Act 2001. The third area which I would like to highlight is geographical indications. From Banarasi to Pochampalli sarees, from Darjeeling to Bangalapalli mangoes, Tirupati Laddu to Dharwad Peda. Geographically indication represents our tradition, heritage and territory. India has approximately 400 registered geographical indications. However, we can observe that there is a great disparity between the states in India concerning GI registrations. Though certain states are performing well, others are yet to catch up. There is an immediate need to take corrective steps to achieve the full potential of geographical indicators. Provisions for stronger enforcement and actions against infringements are the need of the hour. Awareness campaigns, especially in rural areas, are required to be undertaken. There have been a few success stories like Darjeeling tea and Chanderi silk. The success stories need to be studied and replicated in other GI as well. With the startups coming up in the big way across the country, driven by innovative youth, this field of law has become more relevant than ever before. Coming to the judicial setup to deal with issues related to IPR, a brief background of development in law should be looked into. It is historically known fact that prior to 1999 Trademarks Act, all litigation relating to intellectual property was being handled by the district courts and 5 high courts, namely Delhi, Bombay, Calcutta, Madras and Gujarat. However, in 1999, the Intellectual Property Appellate Tribunal Board, IPAB, was created as a specialized tribunal for dealing with IPR cases. When I visited Japan in 2016 to attend a conference IPR, I was repeatedly asked by the entrepreneurs as how investors friendly the Indian judicial system is. In fact, whenever I travel abroad, from cross-section of posts, I keep getting similar queries. My answer has always remained the same, that the Indian judiciary is absolutely independent. It always treats all the parties equally and equitably. The vesting of IPR jurisdiction back in the High Court comes at the time when the judiciary is already overburdened with the backlog. However, this would not deter us from rising to the occasion and putting in place systems which may be required to deal with the new regime. It is an appropriate moment to build sufficient capacities in our high courts so that intellectual property litigation can be conducted efficiently and smoothly. It is in this context that the seminar organized today is of significant value. The new and additional challenges can be effectively met by strengthening the High Court. Not only do we need to fill up the existing vacancies on urgent basis, but there is also a need to increase the number of judges. With better service conditions, we may be able to attract more and more talent in our court. Judicial infrastructure needs to be improved. Unfortunately, we are not even meeting the basic minimum standards in this area. It has been my endeavor since assuming the office of the Chief Justice of India to put in place an institutional mechanism to coordinate and oversee the improvement of judicial infrastructure. Mere allocation of funds is not enough. The challenge is to put the available resources to optimum use. I have been pursuing the government for setting up the statutory authorities both at the center and the states. I am waiting for a positive reply. It may be recalled that I have recently emphasized about the need of continuous training and upgradation of skills as one of the major challenges before the Indian judiciary. With the advancement of technology, we are witnessing more complex issues in litigation, be it IPR, IT and other fields. The complexities involved demand assistance from experts and specialists in the adjudication process. The Intellectual Property Division of the Delhi High Court and its functioning would help hopefully serve as a model which could be replicated. We have in our midst Srimati Nirmala Sitharaman, one of the most powerful ministers by virtue of holding the purse strings of the country. Her area of research during student days was trade relations with the GATT framework. Her academic research, coupled with practical experience in the Ministers of Commerce and Finance, are a great help in formulating the policies. I am sincerely thanking her for showing the keen interest in these areas. I congratulate the Chief Justice of Delhi and all his companion judges setting up the Intellectual Property Division in Delhi High Court. It is happy and particularly noteworthy the efforts made by Sister Pratibha Singh, who is an authority on IPR. The fact that she left her lucrative practice is a testament to her commitment to public service. Another hard-working judge and very much compassionate and hard-working in the field of intellectual property right, Justice Sanjay Narula, made stellar contributions in framing new rules. My advice to the stakeholders is that while protecting the interest of today, we must not lose sight of the bigger picture. This is where a judicial mind comes into play. While adjudicating the claims of intellectual property rights, you must balance the contemporary claims with the sustainable interests of the future generations. With this, I wish you all success in this endeavor. I am happy to be participate in this seminar. Thank you once again for giving me this opportunity.
Thank you, sir, for your words of wisdom. I'm sure they will serve as guiding light for us. I now request Honorable Mr. Justice Sanjeev Narula, member of IPG Committee, to deliver the vote of thanks.
Honorable the Chief Justice of India, Justice V. N.V. Ramana, Honorable Union Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman, Honorable Chief Justice of High Court of Delhi, Justice D.S Kothari, my learned colleague and Chairperson of the Ipg Committee, Justice Pratibha Singh, Honorable Judges of the Supreme Court, Chief Justices of the High Courts and other judges, my esteemed colleagues and the learned members of the bar. I consider it a great privilege to propose today's vote of thanks. On behalf of High Court of Delhi, I express my sincere gratitude to all the distinguished guests for making time to attend the event. Your support and enthusiasm has made this event a resounding success. I join my colleagues in thanking the Honorable Chief Justice of India in setting the tone of the conference. Sir, you are very modest, but we all know about your vast knowledge on these subjects, including IPR. You have highlighted the public interest and the importance of creating awareness, which I think is the dominant factor that has to be kept in mind for development of law, and that indeed is the bigger picture that you have talked about. Your valuable thoughts expressed on this occasion will serve the field of intellectual property rights and the newly constituted Intellectual Property Division in good stead. Thank you for your presence, your advice, and constant encouragement. On behalf of the High Court of Delhi, my brother and sister judges, I convey our gratitude and heartfelt thanks to today's guest of honor, Honorable Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman, for accepting our invitation and gracing us with her presence. Madam, your insightful speech has truly set the benchmark for a series of resourceful and illuminating discourses on IP dispute resolution, which will indeed develop the IP ecosystem that you have discussed. The role of the judiciary in strengthening and supporting startup innovations and R&D is indeed vital, and we take note of that. I also extend my thanks to the Honorable Chief Justice of High Court of Delhi, Shri Justice D.S Patel, whose presence marks his deep-seated commitment towards innovation and streamlining IP adjudication, recognizing that Delhi is the hub of IPR matters. Without your clarity, vision, and progressive ideas, creation of the IPD would not have been possible. In a short span of time, you have led this court into making important strides towards formulating an effective framework for adjudication of IPR disputes, which I am confident would further contribute towards IP jurisprudence. I would also like to take this moment to thank the Chairperson of Ipg Committee and my esteemed and dear colleague, Justice Pratibha Hussain, to whom we all are deeply indebted for her painstaking efforts in establishing the IPD and for ensuring that its bones are ironclad. You have laid a strong foundation for cultivating specialization for resolution of intellectual property disputes. I'm delighted to know that this coming Monday, she will preside as one of the first judges in the exclusive IP division of the Delhi High Court in the format that we both had envisioned. This is indeed a defining moment, and I wish her the very best and look forward to seeing the rules being applied in practice. I also take this opportunity to thank all the members of the bar and the stakeholders who played a pivotal role in drafting of the IPD rules. Without your proactive contribution and valuable insights, the rules would not have been fructified in the present form. On behalf of the Delhi High Court, a very special thanks to all the distinguished Chief Justices, the judges of the Supreme Court, judges of the High Court, and all the dignitaries in the audience who have made time from their busy schedules to be with us this afternoon. I would also like to acknowledge the contribution of the administrative staff of the Delhi High Court, the registrars, law researchers, secretaries, and other members for the relentless effort and support for making this possible. On behalf of the Delhi High Court, I extend my heartiest congratulations to the entire legal fraternity and especially the IP community. The full-fledged IPD assures dedicated judicial resources and time, and with time, this will generate numerous opportunities for all of you and encourage innovation and creativity. With your continued support, the Intellectual Property Division shall revolutionize and bring efficiency and consistency in the IP redressal system in our country. Thank you.
Thank you, sir, for the Thanksgiving. I request all to please join us for high tea. We will reassemble here at 12 p.m. for the panel discussion. Thank you.
Hello, 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 check, hello. Hello.
Hello. I would request all the invitees to kindly take their seats. The session is about to commence. Kindly please take your seats.
Follow.
All the panelists, please, I would request them to kindly come on the dais.
Follow.
I welcome all once again. We now start with the panel discussion on adjudication of IPR disputes. For this, I request the moderator of the event, Honorable Mrs. Justice Pratibha M. Singh, along with the panelists, Honorable Justice Sonia G. Gokane, Judge Gujarat High Court, Honorable Justice Soman Sen, Judge Calcutta High Court, Honorable Justice Gautam S. Patel, Judge, Bombay High Court. Honorable Justice M. Sundar, Judge, Madras High Court. Honorable Justice Sanjeev Narula, Judge, Delhi High Court, to kindly join us on dais.
Justice Narula. Can I request the attendees who are sitting in the balcony to come downstairs?
Check.
Can I request everyone standing in this ways to come down? Please take your seats. Okay, a very good afternoon to all of you. We now come to the technical session and the panel discussion in this seminar. And I must say this is a historic moment for all of us because never before have all the 5 high courts who have the intellectual property jurisdiction come together for a panel discussion. I'll start from this end by welcoming Justice Sonia G. Gokani from the Gujarat High Court. Justice Sonia, if I'm not wrong, is a graduate in microbiology. Am I right? Yeah. So she's a technical judge and she's written a beautiful piece on human rights and IPR, which is there in the brochure. I would commend you all to read it. Thank you, Sonia Ji, for agreeing to be with us today. Justice Somen Sen. Somenda and me have gone back several years and he's authored several IPR judgments from the Calcutta High Court. We both had the pleasure of judging a moot at the IIT Kharagpur about a few years ago, where Justice Bose was also one of the chief judges. Welcome, Somenda, to this event.
Thank you.
Next, I have the ultimate pleasure of inviting Justice Gautam Patel, GP as I call him, from the Bombay High Court. We had a fight on how I should address him, so we finally settled on GP. So he is, I'm hoping he'll have a lot of firecrackers for all of us today.
Yes.
His capabilities in intellectual property are quite well known. Authored several landmark judgments in intellectual property from the Bombay High Court. And also, it's our pleasure to share stage today, GP. It's wonderful that you're here.
Thank you so much.
Though it's a working day in Bombay High Court today, he's taken the time out to come with the consent of his Chief Justice, obviously. Justice Sundar from the Madras High Court, an avid practitioner and holding the fort, as they call it in Madras. Welcome to this panel discussion. And Justice Sanjeev Narula, stop being mischievous here on the stage. From our High Court to today discuss various issues concerning intellectual property. It's a pleasure to have so many Chief Justices and judges from brothers and sisters from across the country and the members of the IP fraternity who've turned up in large numbers. I'm sorry, a large number of viewers are still viewing this on YouTube, which I'm aware of. Sorry, we couldn't accommodate everybody due to COVID-19 and to the DRDO, protocols of the attendance and the security concerns here. Welcome one and all, both online and offline today. Today we start the panel discussion with 2 to 3 minutes of opening comments from each of the judges. I would just put one common question to all of them and give them 2-3 minutes to open their discussion. Please introduce Sonia ji, and the ball will roll with you. Please introduce the manner in which IPR cases are dealt with in your High Court prior to the abolition of the IPAB, and what kind of litigation was being seen earlier. And we'll come to the future a little later. Thank you so much. We start the panel discussion. Please switch on the mics, the caller mics, please. Use this.
Hello. Am I audible now? Okay. Namaskar and good afternoon to everyone. This beginning, which has been made by Delhi High Court, on behalf of myself and my High Court, I would first of all congratulate. It is something, which is remarkable and worth emulating. With that, I would say that our High Court does not have the original jurisdiction. We largely have the appellate and supervisory jurisdiction. So, in relating to the trademark, copyright, patent, designs, intellectual property law, we exercise this jurisdiction, and essentially everything needs to be filed before the district court. And as we are aware that in patent and design matters, wherever a particular defense comes, then only it gets transferred to the High Court. And we have presently those 34 suits which are there, and therefore presently we don't have that much of pendency.
34 suits is a lot in patents.
Yes, the total pendency of the cases relating to intellectual property in the district judiciary, of course, we have about, as on 24th February, is about 4,328
That's
matters.
an immense number.
And the district judges, they have the original suits under the trademark and other matters, which are nearly 644. And the junior division and senior divisions have about 3,684 matters. The matters which have come from IPG after the abolition, so nearly in the High Court, are about 400 matters, 386 to be precise. So these are the number of the matters that we have. And as before this, whatever that has happened, we were dealing with it in a regular way as what would be dealt with in every High Court. So it was not a specialized division, but as we've always welcomed the new and the noble thoughts from everywhere. And as the Rigveda says, Ano Bhadra Kratvo Yantu Vishwataha, we invite the noble thoughts from everywhere and around the corner. So we would also be now thinking along the line of the IP division in our High Court, which will be, and there are a couple of suggestions along the way, maybe we'll be doing.
Thank you. Thank you for your opinion. Justice Sen.
Being part of the first letters patent current High Court, Calcutta High Court has a legacy of having this trademark, patent, intellectual property rights matters over a period of 150 years now. We have the original jurisdiction as well as the appellate jurisdiction. But as I must confess that so far as the intellectual property division that the Delhi High Court is presently having, we do not have that. I could gather information from my High Court that so far as the transfer petitions are concerned from the IPAB, is about 618 in number. Out of which 38 are copyright cases, 234 patent cases, and 364 trademark cases. Original filing, after these figures I have received, is about 8 trademark actions and 10 patent cases. District judiciary by reason of this Commercial Courts Act, also having there are large filings, a number of filings in the district judiciary also, because people are becoming more conscious, they want to secure their rights. But I must say that the rules framed by the Delhi High Court in this regard, we can also adapt. We need to discuss these rules. They appears to be in tune with, in consonance with the established practice all over the world. So it's high time that we adapt or we maybe improve upon it through discussion. And I must congratulate the Chief Justice of Delhi High Court and SSC and the entire team for making this very well drafted rules, which would help us to decide these matters, basically intellectual property matters which require a special kind of adjudication more effectively and efficiently.
Justice Gautam Patel.
Thank you, Pratibha. I came to IP out of curiosity. I had really no practice in IP. I'd done a couple of trademark matters. But I had studied it because it was a curious subject. And then I came to it as a judge, and I was just lucky to have a lot of it. But perhaps my lack of a practice became a bit of an advantage, because I began to see different things about IP law and what IP law actually means. Now, one of the things that I really do believe, I just mentioned it to Chief Justice Patel, is that I think we must stop even acting as if this is a competition between high courts. It's not. We are in this together. We have to have IP divisions to deal with individual IP rights, and I'll get a chance perhaps from Pratibha, because I have another take on what maybe we need to jettison this word rights in favor of IP identity. I'll explain that if I get a chance what I mean by that, because IP actually controls entire businesses, small to large. It's not just a matter of rights. This is something we all have to work on together. I'm very grateful that the Delhi High Court has established this. I think it's a template which we need to modify with our own modifications for future. And it's not a question of Bombay's lost IP litigation to Delhi or Delhi's taken IP litigation. I couldn't care less. I couldn't care less if the IP matters gone to Delhi. I'm happy, let somebody decide this. Let me give you one quick example from 6 months ago. I got an IP litigation, a trademark matter, one of those phone pay paraphrasings. And I think Justice Harishankar had delivered something in that. They showed it to me. And I said, look, don't try and ask me to take a different view. Between the two of you, he's taken that view. I'm going with that view. I'm not budging from this position. Now, you suffer a consequence there. Stop taking a chance. You're going to suffer the same consequence here. Finished. End of story. I'm not going to deviate from this position. We have to see this together. Otherwise, there's going to be a mudding. We have complications in mind. When you say the Bombay High Court has original and appellate jurisdiction, it's only the principal seat that has original and appellate jurisdiction. Our benches in Aurangabad, Nagpur and Goa, and the core seat in Goa don't. Now this creates all kinds of administrative problems, because we would have to set up an IP division that is specific to the principal seat in Mumbai and find some other variant within a variant for Aurangabad, Nagpur, which will be getting the IP litigation in an appellate form. Nobody's yet figured this one out. The IPAB influx, counted as of Thursday evening, is 2,510. So far unsegregated. And we had another problem, which you don't intend. We just didn't have the physical space to store these papers. So now we're looking at some other strategy to get rid of some of our jurisdiction so we can make space physically for the IPAB jurisdiction. I mean, it's just unbelievable that this has become a question of real estate in Bombay, just fitting the papers in. How to deal with the different cases, we'll have to see. And then, of course, there's the problem of shortage of judges. that we'll
Okay,
have to
this
do.
is something new. I wasn't aware that only the principal bench has the
But this
original
creates a real
jurisdiction.
problem and a real complication for us, even in conceiving of an IP division. So how to structure it is something that we'll have to look at. Most of our work tends to be in trademark and copyright and design, with actually very little original work in the High Court in patents. I myself have all along come across one which I decided at an infant stage, and there have been two more recently. I don't know about the actual.
Thank you. This is Sundar.
Thank you, Justice Pratibha. Thanks for inviting. Madras High Court is again one of the oldest chartered high courts with an original site. We have a Madurai bench from 2005, which does not have original jurisdiction. Now, on how the original side was dealing with this IPR matters during IPAB was in existence. IPAB Chennai was the hub, as all of us know. Was the proposition which we had to look at as the opening remark. So we are looking at 18 years, say from October of 2003 to 2nd of April 2021, when IPAB, the Rationalization Act, kicked in. But what happened was, in this 18-year span, one interesting event happened, and that was very, very important for the Madras High Court, from what I'm going to tell you now. And that was the advent of the Commercial Courts Act 2015. On and from 23/10/2015, what happened was the pecuniary jurisdiction of the original side of the Madras High Court was 10 lakhs. And therefore, now the Commercial Courts Act, you know, it said 1 crore specified value that time, and it was brought down to 3 lakhs only on 3/5/2018.
Correct.
But all the IPR disputes were commercial disputes because of 21C17. 21C17 commercial disputes. But they were not of specified value. Though they were not of specified value, they came to the commercial division by virtue of the first proviso to section 7 of the Commercial Courts Act. First proviso, just all of us are aware, it's a very august gathering, I don't have to explain, go into. In very simple terms, the first proviso says, any special statute, if it says, a suit has to be tried by a court not inferior to that of a district court. Specified value is of no consequence of all the IPR legislations, trademark, copyright, all that has such a provision. Therefore, what happened was, the commercial division virtually became the IP division in Chennai. This is what happened, and with all humility at my command, had the benefit of being the opening bat there for a good 1 year. We had a good mix, and the IP division, if I may say so, the commercial division is doing very well there. And just two matters, I'll just bring it to your notice and conclude with that. Very, very interesting. Two matters on this, which is relevant to Madras original side. One is, I'm just giving you the citation, 2019 ACC Online Madras 33823. This was a 2007 suit. Another is 2014 ACC Online Madras 163. This is also a 2007 suit. Both are patent infringement suits. The earlier one I mentioned is the Twin Spark plug. I'm not taking the names. Bajaj Business TVS. I'm not taking the name. I did not want to take the names of the companies, but then with Justice Pratibha, I think I don't have to. So the point is this: the latter which I mentioned, 2014 ACC Online Madras 163, was MC Jayasingh versus Mishra Datun. The best part is, that is the first post-trial judgment in India that emanated from Madras, and the author was here for the first session. He is now playing a slightly different role in Tilak Marg. The first of the one, but the first in the country post-trial. The point I'm trying to make is, invariably this time, 20 years patent, and then the time taken is one aspect which you're going to discuss now. In 6 years, we were able to complete the trial, and the evidence was recorded in court. Whereas in contradistinction, the Twin Spark plug, ultimately after 12 years, the suit was withdrawn. and only on interlocutory applications, which was exactly the reverse of Bardhaman. The exact reverse of Bardhaman happened there, and Bardhaman also happened in Madras High Court only, and that was M.C. Jaisingh. And the earliest was Dayal, that was also written by a judge from the Madras, Venkatramaya, T.L. Venkatramaya was the first of the ones where the distinction when somebody was picked up for holding counterfeit, whether they could be criminal prosecution when there is a special statute also. So this much about it. This is how we have been dealing with that. Hope we and we are trying to collaborate closely with Delhi. We have said that in the write-up also. And we're trying to make it as homogeneous as Justice Patel was mentioning. We should make it as homogeneous as possible because IPAB also was a pan-India phenomenon. Therefore, it is very important that we make it homogeneous. We are working in that direction. This much about the opening remarks. Thank you.
Thank you, Sundar. Thank you. Justice Narula, you've had the opportunity to, from July till now, sit in the IP division. What have been your experience and what do you want to say about the Delhi High Court?
Well, so Delhi High Court has been lucky and fortunate to have all kinds of litigations relating to IPR, and everybody present here is aware of that fact. These figures, which Justice Pratibha, you have also seen, indicates a very interesting trend. The trend, the data that I have in my hand from 2000 onwards, if I look at the number of patent cases in 2013 was 17, and 2014 it was 9, 15 it was 1, is now gradually for the last 4-5 years is touching a figure of 50 to 60 cases every year. So this is a very interesting thing to see that there is a substantial growth in the number of patent cases here. Another interesting data, which is that from the IPAB, we have 2,024 cases which we have received from the IPAB. Out of this, 750 have already been registered and 1,274 are yet to be and in the process. So this only indicates why we went ahead for formulating an exclusive IP division, and that was the need of the hour. My experience on the I was designated an IP division, but at the same time was holding the arbitration roster and the non-commercial suits. So the IP division, it's in two form, is only going to be from Monday onwards. So my experience, I would say that the matters which were coming up against the orders, which would traditionally go before the IPAB, those were very small, short issues. And those short issues, with the assistance of counsels, could be disposed of on the first day or maximum the next day. So that's the outlook, and that's the reason we have formulated the rules in such a manner that rather than going for a traditional civil procedure approach to a matter, calling for reply as rejoinders, and that perhaps is not required, and these kind of matters are having short issues which can be disposed of very easily. Second very interesting facet which I noted was one matter will give rise to multiple litigations. So all those matters can now be consolidated in the IP division. So this is the reason we have provided that in the rules. And another facet which I noted that the jurisdiction of the IP division would deal also with the writ petitions for the appeals, which were traditionally being handled by different courts. So they are now brought in under one umbrella. So that is going to be effective and a speedy resolution of disputes.
Thank you so much. Thank you for all your opening remarks. All of you have got a flavor about what is happening in the different high courts. I have now one question, which both Sonia ji and Justice Somin Sen can tell us. Do you think judges in the IP division need technical qualifications? Because this is one of the biggest challenges and questions that are faced by almost all the high courts, including in India and abroad. Some courts follow the system of having non-technical judges, but having technical assistants. And what would be your take on that? Should they have technical knowledge? Is it necessary?
According to me personally, and I think the High Court also would agree, that you don't need to have the technical judges in the sense that they would have to have that kind of knowledge. You know, then only they can be there. You need to have the assistance, good assistance. The research persons also could be there, and there could be all technical assistance that we can have, and that would suffice. Maybe the individual judges can then gradually, as possibly, you know, when you start in any new field, it's something, and as was talking to Justice Gautam Patel, and something he said remarkably well, and he said the enthusiasm of any field to learn. And I believe that, and personally I've always felt that if one have a patience, then the learning is so easy. So it is.
I don't think that judge needs to be qualified, technically qualified, because if you go to the decisions over a period of time, maybe 100 years if you study, you will find far-reaching judgments by judges who may not be technically qualified to address the issues. But what they have done is this, they learned it. And maybe that they were assisted by, at that time, maybe by the lawyers who maybe they may or may not be experts. But as my sister has said, that the enthusiasm, they did not lack the enthusiasm to learn. So even in matters of design, trademark, copyright, we will find that the judgments where the judge may not be pursuing the technical aspect of this, but by his own enthusiasm, or maybe by appointment of a technical expert, depending upon the nature of the dispute, he gets the idea and then he applies his own intellect to the facts of the case and deliver his judgment. For example, you will find that when it is saying patent cases, when the question is that if the judge is, yes, as I said, that if he's technically, if he has that particular science background, maybe whether it is functional or not in the design or in other feedback matters. So there he will be able to assess it with his technical expert, but it does not necessarily mean that he has to have a technical qualification and then.
Okay, so both of you are unanimous that technical qualifications are not required. So, Justice Patel now, the question to you, do you think we can actually harmonize and have a uniform kind of system across high courts? Because each state has different kind of laws, different kind of statutes which govern it, the high courts are differently governed. How do you think this can be brought about?
Okay, tough question. I think we probably have to take one step back and to reassess what exactly we're talking about when we're dealing with IP rights. Now, just for example, this, whether they need training, I entirely agree, because I think one of the things that you must bear in mind is that we must not marginalize judges as being only IP judges. You are trained for this, this is what you do for the rest of your life. They should be able to move in and out of IP assignments periodically as the Chief Justice makes a roster. And sometimes Chief Justices don't have much choice in the roster, Chief Justice will tell us, in the roster that they have to set. There are so many other constraints that begin to operate on them. You have to accept this. Can we have a uniform policy? According to me, we should. We should have a common procedural norm about how we approach these things. I would like to see Delhi as a template with some suggestions which perhaps we will get to in the course of this panel discussion. But I think an important thing is a vision statement that you have to realize that IP litigation is not luxury litigation. It is survival litigation. We are
IP litigation is survival litigation.
It is.
That is Justice Gautam Patel's one-liner up till now.
Why have you called me here, Pratibha? One-liners, I'm serious about this. Look, I'm serious. Let me tell you. It's not always about Hindustan Lever and Pidilite and Asian Paints and Ultratech and Monsanto. It is also about that agarbatti manufacturer, that attar manufacturer. Okay, this bottle looks innocuous. Let me tell you now, there are 3 suits in the Bombay High Court about this on both design and trademark
This is a Tata
against an Amazon brand.
Interesting.
And all the plaintiffs are small manufacturers. They are not big people. But for them, it's a matter of survival. It's a David versus Goliath situation, and this often happens. Copyright, it always happens. What is our protection to the person who provided creative input to this or that field? He is against Z, he is against Sony, he is against the big people in the game. He is not going to be able to deal with different high courts. We have to give him a uniform policy that he understands. Procedurally, set out the law, and consistently, to the extent that we can make it consistent. We can't always be consistent. But this he has to understand, that we are not treating this offhand as all your IPR litigation. That is something
That's a fair point.
that we just can't do.
Justice Sundar, I'm going to move to you.
Yes.
How do we move on from interlocutory orders? Recently, our division bench, Justice Sanghi, observed that in IPR matters, senior counsels take a lot of time and they keep arguing all the time. So, I'm sorry to all the senior counsels here. They consume too much time in arguing IPR matters. And the focus, I remember Justice Lahuti's judgment said, intellectual property matters, interlocutory injunction is very important. But how do we move on from this and have final decisions in IPR matters? How do we kind of restrict time consumption of the courts in IPR matters? Obviously, because there are parties who are very big, they are able to afford senior counsels. The senior counsels are doing their job to the best effect possible. So what would be your take on how do we move on to final adjudications in IPR matters?
Before I attempt to answer that, permit me to answer the first question you directed to Justice Senan.
But I'll cut you off after 1 minute.
Yes, I would take less than, because when senior counsel say I'll take 10 minutes, I ask them how many hours make a minute. That conversion is also that conversion is also possible. That conversion is also arithmetically possible. Coming back to this, on the technical persons, we all know the IPAB composition, 2 technical members, all of us are aware. Now just see how do you, first principle, how do you compare 2 trademarks? Very, very simple. A man of ordinary intelligence, average prudence and imperfect recollection. Don't even look at it from the shoes of a high court judge, because it will be very discerning. So how you compare the marks is man of ordinary intelligence, average prudence and imperfect recollection. So therefore the technical member part may not be. And added to that is the MC Jai Singh Mishra Dhatu Nigam. That was an endoprosthesis, a biomedical product, endoprosthesis, something like a hot tubbing, though we didn't call it hot tubbing. 2 scientists were pitted against each other and their evidence was recorded in court and the deposition has been gone into. So therefore it's some kind of a hot tubbing. Now coming back to this question of how do you reduce the time taken, the best tool available in my humble opinion is CMH, Order 15 capital A of the amended CPC as amended by the Commercial Courts Act. Use 15A to the hilt. We have done it. Use 15A and gravitate towards Roman 13A. Very simple. Roman 13A is summary judgment. Once you say 15A by the clock, you say, well, now you said, the moment you said 1 minute, I was thinking of 15A only. So you're going to cut me off back to my bar days. So I said back to my, so therefore use 15A to the hilt. Please say, this is not necessary. Adding to that, now you have something called redaction under the amended CPC as amended by the Committee, which was not available earlier. If evidence has to be eschewed, you had to take recourse only to section 151 CPC. Now redact the evidence. Say, why should a finance resource speak about the technical aspects of a matter? You say these portions are redacted. And why should a technical person speak about the finance and commercials of the matter? Not necessary. We have done this very effectively and the data speaks for it. Just 10-15 seconds more. And you know, under the Commercial Courts Act section 17 and now the now we also have the rules there made thereunder for the data to be put up specifically. Please see the data for our court. the rate of disposal is 2.5 times the rate of institution.
That's brilliant.
The most effective tool, I'm saying data, I'm not giving the numbers because numbers can be quite misleading, statistics can be quite misleading. I'm saying rate of disposal is 2 to 2.5 times the rate of institution, and the most effective tool we have used is Order 15 capital A, CMH, and Order 13 capital A. These and more importantly, this damages under 35A is also.
Correct.
Now,
We'll come to
35A
damages. We'll come to damages in a minute.
I don't want to. So I don't want to commit trespass now. We'll stop with that because that amendment also comes with the Commercial Codes Act.
Yeah.
You impose damages, make it punitive.
Justice Narula,
Yes.
one interesting set of litigation which came before you was relating to music royalties, because we seem to be talking more about trademarks and patents. So I wanted to ask you, what was the creative way? What was the kind of litigation that you got on the music royalties, and what were some steps that you took in dealing with that litigation?
Yes, so I'll just answer that. So just wanted to share something on a lighter vein on the time taken by the councils on the IPR side. So that was the last day on Friday. The senior counsel was arguing, and time limit was certainly being exceeded. So I reminded him about what division bench has just indicated, and I closed my remark by saying that from Monday onward, God bless the IPD courts. How much time? It's going to start from 10:30 till 4:30. So over to you, Pratibha, on that one. Now coming back to the interesting litigation. So this is a litigation which now you will inherit again, relating to the royalty of the broadcasting stations. It was very interesting one. Here the IPAB had taken a view which was already pending challenge before the High Court, and this royalties have to be renewed every year. So the time limit which had been set by the IPAB was expiring. So all the broadcasting stations were here for fixation of the interim royalty rates till the time you take a final view. And so in this kind of litigation, the best way to streamline the arguments is to have one particular counsel become a nodal counsel for the entire team, who could then assimilate all the data and present it to the court. And then you could have multiple counsels.
So did you appoint an amicus in this?
So I would designate one of the counsels who would I give the responsibility to collate all the replies and circulate amongst. So in this case, we had to issue a public notice in the newspaper inviting comments from the general public. So that had to be then circulated amongst all the counsels.
So how did you collect the data?
So we formulated, so with the IT team support, we created a unique ID, which was then printed in the newspaper, in the public notice, and all the responses from the general public have been received in that particular email ID.
This is in fact a first of its kind. So the IPAB has powers to fix license fee for royalties for music on FM radio stations. So the IPAB has to usually, I mean that was the Copyright Board in its earlier avatar, it had to invite comments from the general public. Now that jurisdiction has come into the High Courts. So what Justice Narula did with the help of the IT department of the High Court was to create an email ID for the IP division specifically for that case, where public could put their comments on that email ID and the judge had to see that. So this is a first of its kind, and I compliment Justice Narula for that innovative way of doing this from the IPAB to the High Court. And I'm sorry I'm cutting you short on this substantive aspect. It's a very nice way that you've done that.
Thank you.
And hopefully the judgment which is now in division bench, so that's why I didn't want to go into the merits of the matter. So it's an innovative procedure. Congratulations.
Thank you.
Now moving forward, Justice Patel and Justice Sundar, what do you think about the culture of damages? In IPR litigation, globally as you're aware, it's very usual for patent cases and IPR cases to be settled into $200 million, $300 million. Recently, one IP settlement went into $1 billion. in the US. Now, how do we inculcate the culture of damages? Because I think that even for the individual innovators, damages is the only way they can be encouraged. And please give us your ideas, both of you, please.
As judges, we have to get rid of this morbid fear of money.
Morbid fear
You
of
have to treat money not as if it's consequential and say, damages, how can there be 100 crores in damages? I don't think that's the correct approach in IP, because IP claims for damages are not only for past loss, but for loss of a potential, loss of a future, and a loss of very many things, including damage to a process of creativity that has gone into it, whether it's copyright or trademark or patent, doesn't really matter. The Delhi High Court has in fact awarded damages in full. This has been criticized in journals, in critical articles, saying there was no measure of damages. And I'm wondering what is the kind of evidence that you would possibly need to measure the damages. Ultimately, it is an estimation that is made by the courts, and we must make that estimation erring, if we are on the other side, simply to discourage other persons from trying to infringe intellectual property rights. An infringer must know that there is a very real money consequence to infringement. This happens in one of only two ways: very heavy damages. Of course, you have to find some jurisprudential framework for it, which is tenable, and also punitive and exemplary costs for mounting a frivolous defense. If we are going to put this under the umbrella of the Commercial Courts Act, we have to leverage everything that the Commercial Courts Act allows us to do. 35A of the CPC is been introduced now by the Commercial Courts Act. It has a range of measures that we can use. We must use them. So in addition to damages, actual costs. You've got senior counsel, all right, his fees.
Justice Sundar.
I was just taking out your Hindustan Unilever, para 61 onwards on damages. This damages 35 capital A, the amendment which the Commercial Courts Act 2015 has brought in is, the cap is now removed.
Correct.
There is no cap now. Now that there is no cap with regard to frivolous litigation, even ex parte decrees, where the defendant deliberately is playing ducks and drakes, have awarded damages so that tomorrow when the defendant comes in and Aranze files Order 9 Rule 13 and says, please set aside my decree, there will be a huge damages there awarded, saying playing ducks and drakes with the court, entering appearance, not completing pleadings, not filing your written statement, cross-examining for some time, and then vanishing, performing the vanishing trick, has also been held to be a frivolous way of contesting a litigation. And 35A damages running into several lakhs and sometimes crores have been awarded by the Madras High Court. So what happens is, when the Order 9 Rule 13 comes, you please say, look at this decree, this part of the decree, deposit a part of it. Then the defendant who is playing ducks and drakes would know that he can't do that. The other aspect, of course, it's the money component which Justice Patel was saying. Now that there is no cap, because all IPR litigations are 21C17 litigations under. Therefore, 35A, 35 capital A, the cap is gone now. As far as IPR is concerned, we can safely say there is no cap. No cap. Do not hesitate to impose huge damages, and even if it is punitive in nature. And para 61 onwards, your Hindustan Unilever, Castle, the five principles, Castle principle, we will apply. That would be, I think, one way of discouraging these matters going up and down.
Sorry, but the question was costs, yes, but also damages as a main relief in the suit, as a money award for damages, as distinct from cost. I think that was
correct. But the thing is, the culture of damages hasn't evolved until now, except except in a few cases. So going forward, I think if we look at the IP division, from what I hear from both of you, the culture of damages ought to be there. Monetary consequences, what Justice Sundar is saying is damages plus costs as well, and that too.
But I can just add, there is in Bombay at least a separate sub-segregation of commercial cases in the commercial division where the claim is 100 crores or more. Now, many of these are 600 crores, 700 crores, 800 crore claims. Why in cases where there are IP claims of 600 and 700 crores, for whatever reason, would you not award it? That is the claim. Why should it be held back
Patel,
by
I
what
must
measure?
say, from my practicing days, that the reason why in Bombay High Court a couple of zeros get added
You don't know
is
cap on
because
court fee.
there is no court fee
No cap on court
beyond
fees.
3 lakhs which is to be deposited.
Yeah, the
Whereas
cap fee is
in Delhi High
capped.
Court, so the double zeros are because of that.
Correct.
Justice Singh, I wanted to draw your attention to the Rule 20 that we have framed specifically for damages, and that's a very interesting one, because I feel in IPR, the award of damages is going to be a big challenge, because these are going to be suits where assessment of damages would require also and help of experts. So in that rule, if you will see, we have provided that in the computation of damages, the court may take assistance of an expert as provided in the Rule 31. So there are experts who go into this area, this branch of law, that how you have to assess damages. So wherever you, and traditionally in a mean profits award, we always appoint somebody to look into the award of damages. And that's why we have provided for this provision that even an expert help can be taken for award of damages.
Thank you, Justice Nalwa. That moves me on to the next question to Justice Somin and Justice Sonia.
What you've
On
been
damages?
asking? Yes, on damages. There's something, an interesting article, I just wanted to share, and that is on an Italian law which has provided for a general rule for calculation of damages. And they've spoken of various areas, which is very interesting, and they say, I would just briefly say on the lost profit, calculation of lost profit and infringers' profits, then equitable damages, punitive damages, and they've also shown as to how and in what manner the calculation needs to be taken care of, the reimbursement of out-of-pocket costs, which includes the technical expert, costs incurred or the investigation, cost of time the plaintiffs and employees and IP consultants have taken, liability without negligence, and the reimbursement of the legal cost, which includes the lawyer's fee, court expert's fees, the fees of the IP attorney, etc. So I think this is a trend which they said that's been being followed everywhere. We can also adopt this.
Justice Somin, on your view on damages.
You see, in a trademark matter, normally my experience is that when in the introductory stage you give the application and the other side comes after the notice is served and he said that, well, I was not aware of this, and he appears to be an innocent infringer, let's put it this way, then I think the court should take a lenient view. Or where suppose he had the registration, he did not renew it in between the infringement basically. So there may be various considerations while assessing the damage in an infringement action. But at the same time, going back to the position of the pneumatics, where the House of Lords said that it should not be to compensate the plaintiff, but not to punish the defendant.
Not in a penalty.
Not in a penalty.
Not
Not to
in
punish them. Carol has given a very good example that said that when you assess damage in a patent case, Terrell said that it should be equated with the amount the infringer would have to pay had they had a license upon the terms normally granted to the patent. So this is in a patent case.
Good test of how to do it. What would you now think about moving on to the next topic? In our rules, we now acknowledge that the judges who are in the IP division may require scientific and technical assistance. So we've adopted a two-pronged approach for this in our rules. The first one being that we, in addition to the normal law researchers that all of us have as judges in our courts, we've also provided for a pool of technically qualified researchers who will be there on a regular basis, day in and day out. Someone wants to know what is a carbon atom, how does the substitution take place, what is the basic electronic circuit which is in this particular case, what is the mechanical contraption. a law researcher would be able to tell us. So that's the first set of things that we provided. The second level of assistance is in the form of a list of scientific experts which we can, empanel with some kind of undertakings that they would let us know if there is any conflict, etc. So do you think we should move towards having a national panel for all IP judges across the country, which could have experts both from India and abroad, who the judge can actually check up if he or she is available, and with the consent of parties, take the assistance of that expert for any IP division case? Who would like to go first? Sonia ji, would you like?
I think it's a very laudable idea to just start with this. When I read that, particularly in the rule and in your question also, one had found that this is something which really needs to be done. Because individually, every High Court deciding and then choosing the experts, when you have very limited number of experts also available, why not to have it, and then this will be a wonderful, pool nationally, which can be. I can give an example. One of the judges who in the year 2016, when we started with the Commercial Court Act, we had only 3 judges. The regionally, all districts were distributed, and one of them was saying that there was a patent of a machine from Dubai, and that was said to be copied, and there was a litigation. It was about cutting the diamonds, and as you know, the Surat is one of the.
You have an IPR on that, isn't it? In Surat.
So therefore, said we needed, because the source code was something which was needed to be tested. Otherwise, all of the other parameters, the judge said that I could see that everything was, yes, identical. And who would be the expert? And then when the question arose, he said there was only one expert in the entire country who could have just done that. And when it was proposed to the parties, they said one of the parties has got some link with that expert. So we are not agreeable to that. So therefore, what needs to be done? And they said there's somebody in the US, the fees is phenomenal. Parties say we do not mind, but let him be hired. And then they could do it, they both could agree. So therefore, when there is so much of a dirt or there's a specialization, why not to have it? And at a national level?
That's a very interesting anecdote. And thank you so much for this anecdote. Anyone has any other opinion on this international and national experts and we maintaining a common list available for the entire country and all High Court? Justice Kothari.
It's a reservoir that you can draw on across the country, and I think it's absolutely essential. As long as each court can suggest, and there's some sort of a screening policy about that we agree on as to who can be impaneled and so on. It's really a terrific resource to have.
Just one thing I would like to add. This is very laudable, no doubt. But now the kind of complexities that the IPR division is likely to face, because you will find that many of the original jurisdictions that the IPAB would have been exercising would now come back to High Court.
Correct.
So we are going back to where we were.
In 1999.
Exactly. Now, I do not have the data, if anyone has the data, that how many experts at that time the court took the help of those experts in deciding those matters. But now what happened is this: the rapid progress of science and technology, the complexities of the matters are also changing. Now, unless you have a robust system, that means, suppose in Japan, I tell you, Japan, the judge has a scientific pool of scientific advisors attached to it.
Correct. The Tokyo High Court, the IP High Court.
Tokyo High Court has that practice. In fact, those experts, they participate in the court proceedings. They assist the judge to frame how to limit the issues, and then advise the judge that on these points you can ask for any expert opinion either of the parties. So every High Court, of course, there should be a national pool, because there are maybe areas where you may not get experts, many. But every High Court, the judge in the IPG division ideally should have a back office support, where even the retired controller or veterans
That is the other suggestion, that people from the patent office could also be seconded into the IP division, so that with their experience they can help the IP judges, because even in the IPAB there were technical members who were on the bench in the IPAB, but that is not going to happen today. So as we move to 1 o'clock, we are coming to the end of the panel discussion, and I'll be opening the floor for the comments and the questions from the audience. But one elephant in the room which I would like to address right now is, what should be the impact of public interest in IPR litigation? I would like all of you to take half a minute to answer this. Since you wrote on human rights, Sonia ji, please answer this.
I would say the human rights, which I've there also had in mind essentially the public interest dominantly there. Whenever we are talking about it, of course, in your article, I read that 80% it is a common man, the trademarks. It's not something which is very elitist kind of a thing, which ordinarily the people think of. But at the same time, when we talk of the United Nations had decided at the time of its 50 years completion, and it was talking about the human rights and these rights of the IPR. It had said that we cannot forget the indigenous laborers, the indigenous people, and their right to whatever they are doing. So therefore, that element can never be forgotten.
Justice Navila Sanjeev, would you like to tell us about the third-party intervention which we put into the rules because of this human right and public interest angle?
Yes, so I think this is one very important passage which the Chief Justice of India also in his speech mentioned. And the public interest element can never be ignored. In the Patent Act, we have the full concept of compulsory licensing regime, and the process is statutorily recognized. So this aspect in the development of law can never be ignored. I completely agree with it.
Justice Gautam Patel, last word.
No, the public interest actually pervades IP law. When you look at the hybrids in biotechnology, and you're looking at hybrid seeds, and you're looking at the patents there, it actually comes up much more to the fore there as well. So there is no question that we must have some space and element for allowing a public interest intervention in the IP division when required.
Justice Sundar.
This public interest as compulsory licensing in patent, particularly in biomedical products, is a very, very important facet. And in my limited understanding, I'm just placing it for this house to consider. The very concept of patent itself is to encourage this invention. For 20 years, I give you monopoly. The law gives you monopoly so that you encourage invention. This is and that is the reason why in interlocutory applications also in patent you say that the law provides for monopoly. It's a very rare exception where the law provides for monopoly. The law providing for monopoly itself isn't public interest. It's some kind of a begging the question sorts, but then that is the principle. And just briefly, half a minute on costs and damages. I was very conscious that the question was on damages, and I was referring to costs under 35 capital A. I was very, very conscious about that.
I like this duel between two judges.
I was also looking at the clock. The reason is I didn't want to carry coal to Newcastle. I only wanted to say the three categories in Rooks and 5 principles in Castle. All of us know that.
Rooks versus Banana.
Yes. 3 categories in Rooks and 5 principles in Castle. This is, let it be punitive is what I was trying to say. Assuming the damages are punitive, so be it. And this public interest, and particularly in patents compulsory licensing, is a very important. The whole law is based on that. Is my most respectful. The patent law itself is predicated. The underlying sublime philosophy itself is public interest, is what I would say.
It's interesting that patents, everybody includes public interest, but as all judges and practitioners would be aware, In fact, even in trademarks,
Copyright
it is
also.
not the plaintiff and the defendant, but the consumer confusion, which is the test. So the person who is not in the courtroom, that is the consumer, whether he or she would be confused, adds the aspect of public interest into trademark jurisprudence, and therefore trademarks, whether it is a food product, whether it's a big MNC, whether it's a small plaintiff, we all always remember that it's from the consumer's point of view that the decision is to be taken by the court. With this, the question and answer, I think, yes.
One suggestion that I'd like everyone to consider. Because of, well, this is based on my perception of what IP actually involves, and that for many people it's a question of identity and survival. I really believe that there should be, in the IP division, a mandate for one intra-court appeal in the interest of that litigant who has nowhere else to go and can't possibly afford to reach the Supreme Court. Apart from the fact that I think it is now the bounden duty of every judge to reduce the burden on our colleagues in the Supreme Court. It's bordering on a humanitarian crisis.
For a letters patent appeal, can be justice patent.
But the clarity required is that
may require a statutory amendment.
No, the clarity is, let me just explain. The clarity is that if it comes in as an IPAB appellate appeal, the person should not be restricted to the contours of a second appeal on a substantial question of law. He should have the fullness of an appeal on facts and law.
Yeah.
1951 Bombay, in fact, Justice Chawla and Justice Bhagwati said precisely this. If it's an appeal from a registrar, an intra-court appeal lies, just as it would lie if it was an original application before the single judge of the High Court. Make it consistent.
Then we require a provision like the Designs Act,
like the Designs
where the appeal provision is
but
there.
it may require a statutory amendment, but I think this is in the
We have
interest of
been
the
debating this as part of the rules that there is some issue about the intra-court appeal.
That's right.
So I'm sure as the the regime moves forward,
That's right.
it will evolve.
But then we'll have to, for example, what we do in our benches or what Gujarat does will also have to be addressed because they don't have an original.
Yes.
Okay, now it's opening to the floor, but before I proceed to the stakeholders who are here, I'm going to request Justice Mukta Gupta of the Delhi High Court, who's had the opportunity to decide two of the major pharmaceutical patent cases in our High Court. Ma'am, it's your turn. Just to give your experiences and if you wish to say anything.
Thank you, Justice Pratibha Singh. Good afternoon, everyone. I must say my limited experience at the IPR and being able to pen down that judgment of the division bench, the first appeal on merits after a full-fledged trial in the Delhi High Court. And I must first of all convey my thanks to Justice Pratibha Singh and Mr. Praveen Anand for assisting us for months that we were able to cull down some principles of construction of claim, obviousness, and the disclosure, etc. And maybe that is a judgment which helps everybody. And over the years, what we have found is from the various jurisdictions, now there are judgments on all issues which are available. Now, when we started, most of the judgments we had to consider were foreign jurisdiction judgments. Now, with the Bombay High Court, Madras High Court, Calcutta, and all other high courts giving judgments, so the one thing which is encouraging is we have our own jurisdiction judgments, which we now follow, and that somehow we get them applicable in the case. My experience is that patent matters which take a lot of time is the main issue, the waxed one in this is construction of claim.
Correct.
Though principles were cut down, but the main point which takes the main time is the construction of claim, and since none of us have that technical knowledge, of course having experts will certainly help us, but then as our law researchers, but hot tubbing also, still we would need independent experts, and as all the panelists said, we should have a national pool of reservoir of experts so that whenever a matter comes, we are able to access to that expert immediately instead of when the matter comes, then we are locating an expert and then trying to get in contact and be able to find out whether he can give or not. So that expert help should be available to all of us. With the result, it should be, the decision can be very fast in patent matters. Now with the IPAB and all other tribunals being abolished, the High Court will be, the IP division will be virtually like a finding of fact jurisdiction. So there the task will become all the more important. One more aspect which I would like to highlight is that when claims are passed, now we'll be acting as IPAP divisions, doing that appellate job also. If the claim can be specified and concise, because today what we find is the claim is over pervasive, everything falls under that roof. So if that can be concise, the litigation, further litigation always becomes easier further.
Thank you so much, Gupta ji.
Thank you very much, and thank you everyone.
Thank you. I would like to open the floor to judges from across the country. If you wish to raise any query to any of our panelists, please let us know. You could just, I'm sorry, you will have to raise your hand. The mic will come to you and you can take your time, frame your question. In the meantime, anyone from the stakeholders who wishes to put a question to any of our panelists, please raise your hands. Yes, Sachin Gupta from the back. Yes, please. The question has to be 20-second long.
Case management. Case management.
In the normal speed.
But it can be less.
Good afternoon. My question is that rectification applications before the IPAB always used to be summary proceedings. But now that there is an option under the rules that the courts can decide if trial can be led, my apprehension is that it should not be that the rectification applications also becomes another suit.
Sanjeev, would you like to take that?
No, I personally don't think that will really travel into that. It would depend on the facts of each case, as I also mentioned in my opening remarks, that all these kind of matters can be disposed of very easily without really conducting of a trial. So that apprehension, if you have, is not going to be really be a problem.
Okay. It's not very often that judges are here to answer your questions. So please take this opportunity. Yes, please. Please give your name and then go ahead.
I'm Siddharth Bamba. I have a question to just carry forward what Sachin just said. Since now the IPD is the court which will be deciding a rectification as well as a suit for infringement, do we feel that there is a possibility where we can file a consolidated action of infringement as well as a rectification which may avoid multiplicity of proceedings under the rules because there is the same court now?
So that's a possibility if the defendant has a registered trademark.
Yes, on those questions only.
It is possible, and in any case, consolidation of proceedings has been permitted if it relates to the
we
same.
can file one proceeding that is a suit and
you'll
rectification.
You'll have to see it. I'm not saying yes or no.
Then you'll have to let in evidence. Then you'll have to let in evidence.
Rajesh,
just in the lighter way.
I'm getting the impression that these are all litigations coming to you on Monday. Yeah? Make sure that doesn't happen. So don't give them advice.
I'm Rajeshwari, practicing attorney here. We are introducing this concept of litigation hold notice. And in our law, we don't allow very deep discovery. So what is the thought behind this? Because this is, although it's a concept which I'm aware of how it plays down in the US, but that sort of discovery we don't allow here. So what is the thought that we all had here? I just want to know.
This is Arula.
So this is in line and sync with the global trends as you yourself indicated. And in many cases, we do feel that the preservation of the records is necessary because often the parties would destroy them. So we had a lot of deliberation on this rule before we formulated it. We had to balance it that it could not be that you simply issue a litigation hold notice and never really come up with a litigation subsequently. And would the other side be then mandated to maintain that record endlessly? So we have balanced that. by providing that within 1 year, in case you do not come before the court, the other side would be entitled to just move further with it and not really be bound by law to retain that information. So that is the intent, that in case a party is before the court and it relies upon a document which it subsequently wants to discover, it should not fade away, it should not be destroyed or eliminated by the other side.
And there is a linkage between the preservation of the documents and the other question on damages. So in proof of damages, you may require production registers, for example, or production records could be used for proving damages and in that award of damages. So it's useful for that linkage.
Absolutely. We have at least 3 judges from Karnataka High Court, including the Chief Justice. I'm aware that the Karnataka High Court, which was my home, in the City Civil Court in Karnataka, there are specific IPR courts in Bangalore City. So what would be the kind of litigation that comes to the Karnataka High Court? Do you see that there will be an increase in the litigation in Bangalore? Would any of the judges from the Karnataka High Court please? Oh yes. The Chief Justice of Gujarat is from Karnataka. Please.
Yes, good afternoon.
Okay. Yes, Dinesh.
We have at this point of time about 41 matters pending in the City Civil Court and 28 in appeals and 2 writ petitions in the IPR.
Okay. So you are expecting much more litigation now?
Yes, of course, likelihood.
Do you have a specific judge in the High Court who deals with that?
Not a designated. We have a roster, but we have only one matter there where the writ petition or the IPR sets.
Any other judges from any other high courts who would like to say something?
Justice Sarab.
Hi. You see, in matters that have come up before me, in disparagement cases, an argument is raised by the defense that they have a right of commercial speech under Article 19(1). And studying precedents, etc., I found that judges had dealt with that issue. Even I dealt with it. It's in hindsight now, I felt that the entire argument that is made is fallacious, simply because right of commercial speech is something which is a right of expression under Article 19, which is actually only available to citizens and not to a commercial entity. And that is a right you can enforce against the state and not any other company or a corporate or something like that. So do you really think it's a fallacious argument, or it would come under the idea of public interest, etc.? The public has a right to know this, so whether that can be expanded on that.
There is no Article 19 element in that at all. There can't be. So you're right, there can't be an Article 19 element.
There shouldn't be, but that is the argument that is there. If you see lots of judgments, it's dealt with.
But I think it's a misdirection there.
That's what
it's more in the nature of a defamation action.
That's right. It has to be a tortious action.
That's right. It's a tortious action.
I think the word commercial speech, why it's being confused.
But it's been discussed by the Supreme Court also at length. That's why I was.
The reason why it's being used is because of the Tata Press decision, which says 19(1)A also includes commercials.
That's right. It says that, but that was actually said in a different context where, directory and yellow pages and things like that.
That was justice.
Actually shouldn't be followed by any of the judges.
That's the question of somebody putting his entry in the directory in the Tata.
That's right. So
that's Justice Shekhar Saraf from Calcutta. Justice Amit Bansal, I'm going to catch you here. You've been sitting on the commercial IPD side for some time, and I've seen a couple of very good judgments from you. Would you like to share your experience?
Yeah, it's been about 6 weeks that I sat on this roster, and just like the Honorable Chief Justice of India confessed, I was also quite a layman in this field. So when I started on this in this branch, I was a little apprehensive, but yet very excited. So I did do my homework. I met some of our current judges and some of the former judges, and got a full orientation for the field. And I must say the bar has been very supportive. Obviously, they gauge the judge is new to the subject, and they're very patient and take you through, in a patient manner through the various provisions, which for them would be an everyday bread and butter submission. But yeah, I have thoroughly enjoyed these 6 weeks. You mentioned about public interest, so that is something I was not so much aware of a public interest in a trademark suit, for instance. But on my very first day on this roster, I ended up hearing a case involving a rectification of a register. And,
Purity of the register.
Purity. These terms were quite alien to me. Purity of the register and the public interest. So it was. Well, it was a very fascinating experience. I was lucky that the counsel were patient and took me through it. And I was in a position to deliver judgment.
Thank you so much. Adarsh Ramanjan, I think.
Okay. As a counsel, my greatest fear in arguing a patent matter, particularly at ad interim stage, is a potential loss of communication on the technical side. I believe there may be a necessity for courts and judges to have expert advice even at the interim stage, given how hotly debated interim injunctions are. The views of the panel on that.
Yes, I don't think there can be any two opinions. There can be no two opinions about that.
Certainly,
but there can be no two opinions
the
about.
concern is, do we need to have a system of an expert advice even at the interim stage?
Suppose,
Not
for
just
example,
absolutely.
in a patent matter, suppose the defense takes a point that is obvious. Obviousness is the defense. Even at the interview stage, that is likely to come up. And at the interview stage, generally it is on the basis of opinions that we decide. Maybe some high courts have adopted a trial on evidence in a particular issue. That's a different issue altogether. But in case of obviousness, generally the trend is that you should have an expert opinion, unless it is too obvious to the judge.
You need to have an expert who is a person of an ordinary skill in the art, which one of the judges called him as an oxymoron.
And in any case, even prior to, even when IPAB was operational, in patent cases, you will have the defendant challenging the validity of the patent. That in any case was there, and there was also a provision for transfer to the High Court. Therefore, that is something
I'm being suspicious by nature, but is there something more sinister in that question? Which is that if I am making an interim application and I stand up and say you need an expert, you have to get the expert. No. Then the answer is no. Okay.
No. We don't know whether something is coming up before Justice Pratibha on Monday.
That's correct.
Okay, now we are reaching the end of the panel discussion. It's almost 1:30 and we've all had a very long morning. A lot of you have traveled from outstations. Some of them had their flights diverted. There are 2-3 questions, but we can take them offline, not on the panel anymore, because everybody has to move on for lunch as well. But before that, I would invite our Honorable Chief Justice, Justice Patel, and Justice Sanghi, I don't know if Justice Mudul is here, to please come and felicitate each of the panelists on behalf of the Delhi High Court. And I really thank everyone from the IP fraternity for having been here. Please, sirs, please come on stage. Hanji, Justice Mudul.
I would request Honorable Justice Mr. D.N. Patel, Chief Justice, Delhi High Court, to kindly present a token of gratitude on behalf of Delhi High Court to Honorable Justice Sonia G. Dukani, Judge, Gujarat High Court.
A huge round of applause, please. Thank you, ma'am. Thank you for joining us. It's been an absolute pleasure.
Sir, I again request you to kindly present a token of gratitude on behalf of Delhi High Court to Honorable Justice Soman Sen, Judge, Calcutta High Court.
Aye, sir. Okay.
I now request Honorable Justice Mr. Vipin Sanghi, Judge, Delhi High Court, to kindly present a token of gratitude to Justice Gautam S. Patel, Judge, Bombay High Court. Sir, I again request you to present a token of gratitude on behalf of Delhi High Court to Honorable Justice M. Sundar, Judge, Madras High Court.
Thank you so much, Justice.
Thank you, sir. I now request Honorable Justice Ms. Mukta Gupta, Judge, Delhi High Court, to kindly present a token of gratitude to Honorable Justice Pratibha M. Singh, Judge, Delhi High Court. Thank you, ma'am. Ma'am, I again request you to present a token of gratitude to Honorable Justice Sanjeev Narula, Judge, Delhi High Court. Thank you, madam.
On behalf of the Chief Justice and the Delhi High Court, I thank each one of you, especially the judges who've traveled all the way coming here to participate. And hopefully this is just the start of a new beginning. Let's all stand for the national anthem.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उत्कल जलधि तरंगा तब शुभ नामे गाजे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all to kindly join us for the lunch.